Hi friends, welcome back to the Legal Artist. In this video, in this scenario, we are going to discuss about the freedom of trade, free trade and commerce and intercourse under Article 301 to 307. 301 to 307 clearly state regarding the free trade and commerce and intercourse within the state and within the territory of India as well. Let's move on to the evolution of Article 301. Actually, we borrow from this article from Australian Constitution and USA as well. In the Australian Constitution is the absolute freedom, but in India, Article 301 have some reasonable restrictions. That is the difference between India and Australia. And let's move on to the definition of the Article 301. Article 301 guarantees discourage harmful environment practice. These are the main grounds to collect the government for the welfare of the people, for the interest of the environment, for the people. And compensatory tax also related to public interest, and these tax are imposed to recover the cost of providing a specific services that facilitate to trade, such as toll taxes for road maintenance and infrastructure used for business activities. These are the main grounds to we are collecting the compensatory tax. They are mentioned in the Article 301. And let's move on to the uh, in the in the 1961 Attibari Tea Coffee Company was a state of Assam. In this scenario, the Supreme Court ruled that such tax directly violates the, like in the fact of the case we can see in this case involved the Assam Taxation Act, which levied and tax on goods and transmitted through the inland waterways and roads. The Supreme Court ruled that such tax directly violates the freedom of trade under the Article 301. But in 1963, Automobile Transportation Limited versus State of Rajasthan. In this case, the actually on that time in the when the going on to the state of Rajasthan versus automobile transportation case, Attibari case is overruled by the Supreme Court. In this case, the Supreme Court upheld the imposition of tax on motor vehicles by the state of Rajasthan, starting that the tax was compensatory and regulatory in the nature. The court held that such taxes which facilitate to smooth running of the trade and commerce and intercourse and did not violate the Article 301, as we all know that already compensatory and regulatory tax for the welfare, for the interest and for the people. For the peoples we are making the tax, we are collecting the tax. And let's move on to the restriction on freedom of trade. As we all know, the in the first pages of the PPT article, we have some reasonable, some sort of restriction compared to Australian Constitution. Australian Constitution have a absolute freedom in the freedom of trade and commerce and intercourse, but we have some sort of reasonable restriction. Restriction on trade and commerce. Article 302 to 305, talking about the restrictions. Although Article 301 guarantees to the freedom of trade and commerce and intercourse, this right is not absolute, as we all know that already. The Constitution allows for the certain reasonable restriction to impose by the Parliament and state legislature, especially when they require in the public interest. As a law student, we have to know that public interest, this is the main ground, friends. And let's move on to the Article 302. Article 302, power of Parliament to impose the restriction. Article we have know that for the public interest, power of Parliament, power to the Parliament has a power to impose the restriction. Article 302 grants the Parliament the power to impose the restriction on trade and commerce, but only when it is necessary in the interest of the public. These restriction may apply to the intrastate trade. Parliament has authority to decide when the restriction are necessary, what the form of they should take. As we all know that for the public interest, the Parliament has exclusive power to impose the restriction. And let's move on to the Article 303, restriction on Parliament's power. Article 303 defines the imposes and restriction on Parliament's power to discriminate between the states. The Parliament cannot create the law that's favor on one state over the another state in the relations of trade and commerce and intercourse, except in the cases where the scarcity of the goods exists in one state. It's clearly mentioned the ingredients cannot create a law in favor of one state except in the cases where the scarcity of the goods exist in a one state. These are the main ingredients to we can challenge in the High Court or Supreme Court of India. And let's move on to the Article 304, state power to regulate the trade. Article 304 defines that allows to state to regulate the trade within their territories. State may impose the taxes on the goods goods import from one state to another state, and provide that tax does not discriminate against the goods produced within the state. However, the restriction imposed by the state must have presidential assent before introducing. The state government or state legislature, while introducing any restriction on freedom of trade and commerce, the state legislature should be assent taking assent from the president before introducing any restriction.